companies are opinion factories, and they bring in and pay the scientists, who are the mouthpieces.
All right. Barbara 16 will not come back. Be seated.
All right, let's go ahead and set forth our assurances for the record. We'll get there, Pepperman and Tim Gordon.
Good afternoon, Your Honor. Jim Neale, Nicholas Hoffman, David Spurlock for UNFW.
Good afternoon, Your Honor. Joel Odou and Matthew Kaufman, Wordsmith and Government for the Real Water Defendants.
Good afternoon, Your Honor. Scott Rasmussen, Burgess & Cummings for Hanna Instruments.
Good afternoon, Your Honor. Jim Cavanaugh, Gordon Reeves, the third-party defendant, Real Water Tennessee, LLC.
Good afternoon, Your Honor. Rob Robbins for Milwaukee Instruments.
Okay, once again, good afternoon. And tell me, where do we go next?
One little anecdote that Mr. Spurlock and I have confirmed over lunch is the Shoshone Bottling Company was about 2 blocks that way on Main Street, over by where the ice house used to be.
I know where that is.
Okay, so it was right past where the ice house used to be. And Mr. Spurlock thinks he even knows who owned it. But just an interesting anecdote since we've been talking about Shoshone so much.
Oh, absolutely.
Your Honor, I have a scheduling request or issue I'd like to bring to the court's attention.
Absolutely, sir.
Joel Odou on behalf of Real Water. We have a hearing, Real Water has a hearing with Special Master Hale at 3:30 on the Arambola case. If we take a break around that time, that would be fantastic. In addition, Mr. Kaufman will be on Blue Jeans, and the court would not need to wait for me if I'm not back by the time the break is over, because he is prepared for the next 5 motions.
Okay, that's fine. And we do have to take one break at a time. Around 3. We'll take a break around 3 anyway, right? Okay.
Thank you.
Okay. Where do we go from here?
Your Honor, I believe the next motion in sequence is UNFW's motion in limine number 15.
Thanks. Defendant United Natural Foods West, motion to exclude, motion limiting number 15 to exclude cross-examination of Dr. Alex Revchuk based upon association with exponents. Is that it?
That's the one, sir.
Okay, all right, sir.
All right, Your Honor, Jim Neale on behalf of UNFW. John, can you pull up the Revchuk report, please? Dr. Revchuk has been alluded to a couple times in these proceedings,
Right.
Your Honor. He is UNFW's water processing engineer, and he is employed by a consulting firm called Exponent that you may have heard of or run across or seen other experts from. It's about 1,000 consultant firm, a large firm with offices all over the United States, but headquartered, I believe, in the Bay Area in California. I want to make clear what we're not doing with this motion, Your Honor. We understand that cross-examining attorneys should be given wide latitude. We understand that anything Dr. Revchuk has done is fair game. We understand that bias is relevant. And the motion does not seek to preclude a cross-examiner from exploring any of those topics. What the motion is intended to do, Your Honor, is specific and targeted. At Dr. Revchuk's deposition, we were provided, as was the course of all the parties in this case, we exchanged binders beforehand with exhibits in it. And although Mr. Kemp did not go into it during the deposition, included among those materials was tab 15, which included 62 pages of different investigative journalism articles that I would call advocacy pieces that were targeted not at Dr. Revchuk, not at anything he'd done, but at other people in Exponent whom the authors had taken exception with. They were critical of Exponent's corporate affiliations. They were critical of Exponent's, some consultants' actions at Exponent. I don't think there was nothing in there about Dr. Revchuk himself. So when we look at the plaintiff's opposition to this motion, I think the justification for cross-examining Dr. Revchuk on the actions of other consultants at Exponent is this, quote, as an Exponent authored report, the company's corporate character, that is Exponent, for veracity and honesty is admissible to attack Revchuk's credibility. And the plaintiffs cite NRS 50.085(1) for that proposition, Your Honor. John, could you pull up that statute, please? And I know the court's familiar with the character evidence statute, but the statute itself prevents exactly what the plaintiffs would do here. To reiterate, Your Honor, we're not moving to exclude any effort by the plaintiffs to cross-examine Mr. Revchuk on what he's done or not done in this case, what his opinions are or are not in this case, how they may have changed over time, shortcomings he may have in his report, a factual basis for it. All of that is obviously fair game. But what the character statute makes clear is that only the character, only opinion evidence regarding the character of the witness is admissible, not the corporate character of the witness's employer. And that's what we seek to prevent here. This report and these opinions are not the opinions of a 1,000-person consulting group. They are the opinions of one engineer. And that one engineer is the one who developed those opinions. That one engineer is the one who developed those opinions. John, can you go back to the Revchuk report, please? That one engineer, Your Honor, could you go to page 2, please? That one engineer, Your Honor, if I could refer you to the screen for one moment, is the one who put his signature, and there you go, John, thank you. Put his engineering seal for the state of Nevada on the line for this report. And if there's a shortcoming in his work, have at it. But to the extent he has a colleague whose work was called into question that's completely independent of this report, completely independent of these opinions, completely independent of Dr. Revchuk himself, that's not the proper subject of cross-examination. It's certainly not the proper subject of character evidence under 50.085. And that's too broad even for the wide latitude we'd extend on cross-examination. The other problem, Your Honor, is the source of the criticism itself. John, if you could go please to tab 15. And these are the 62 pages, Your Honor, of critiques, again, not of Dr. Revchuk or anything he's done or failed to do, but of others at and formerly at Exponent. So for example, the first article is an opinion piece titled, okay, so I hid my industry ties, but everybody's doing it. This is obviously hearsay, it's opinion evidence. The author of this is not subject to cross-examination, and it shouldn't be used, it doesn't concern Dr. Revchuk, so it shouldn't be used to cross-examine him. Page 4, please, John. This is a magazine of corporate responsibility saying big companies and legal scrapes turn to science for hire giant Exponent. Again, great investigative journalism, and I don't mean to suggest that the criticisms aren't valid in that form, but that's not proper for this court, and that's not a basis to cross-examine Dr. Revchuk on, unless he's quoted in this article or his actions are specifically taken to task. Page 24, please, John. This is one from the Environmental Working Group, Your Honor. The Environmental Working Group challenges Postenbach to come clean. And this illustrates my point well. Dennis Postenbach is our toxicologist. If the attorney who is cross-examining him, he's not with Exponent any longer. I don't know when he left. It may have been before Dr. Revchuk was even there. If the attorney cross-examining Dr. Postenbach wants to go into the acts that are alleged in this article, that's fair game. Dr. Postenbach has to answer for them. But Dr. Revchuk, simply because of an association with a 1,000-person consulting firm, shouldn't have to. Page 28, please. This is a publication from the Center for Public Integrity. Again, an advocacy group, respected advocacy group, but nonetheless an advocacy group, talking about how Ford spent $40 million to reshape asbestos science, the recipient of which, I don't know if it was exclusively, but in some large part was Exponent over many years. Page 55, another newspaper article. This one from the New York Times. This one, I believe, also concerns Dr. Postenbach. Fair game for him, but not for Dr. Repchuk. And then finally, page 59, Toyota calls in Exponent Inc. as hired gun from the Los Angeles Times. These are critical of their legal commentary, Your Honor, their opinion pieces, their hearsay. They don't concern Dr. Repchuk. They're not relevant to him personally. They don't illustrate his character, and therefore they don't implicate 50.085 and don't satisfy the exception to the general rule that character evidence is inadmissible. In response, the plaintiffs have cited 4 cases. I think that 3 of them are criminal cases, Jones, Lloyd, and Krug. And they all stand for the general proposition that on cross-examination, witnesses are subject to, courts will give cross-examining attorneys wide latitude to examine the witness on bias. And that's certainly true, but in each of those 3 cases, it was something that witness had done. In the first one, it was that witness being the victim of alleged police brutality and therefore having a bias against cops. In Lloyd, it was a witness having previously provided alibi testimony for a criminal defendant and her proclivity to do so. Perfectly fair game. In Krug, it was a witness's tendency to snitch on fellow inmates. And again, that refers to that witness's acts or omissions or personal bias. In all of those cases, that's fine. None of that is represented here. So while we think that, and then the final case, Your Honor, was Hall, which allowed the cross-examination of a witness based on his occupation. And I forget the specifics there, but it had to do with his personal business dealings and the financial incentives he might have to provide testimony in a certain manner. That's fair game. But what that doesn't do is allow the cross-examining attorney to cast a wider net to cross-examine the witness based on something that a consultant who happens to be employed by the same 1,000-person organization might have done elsewhere. I can't cross-examine Dr. Hudson, for example, who is a faculty member at West Virginia University, on something another faculty member at West Virginia University has done. And the same Guskander rule ought to be true for Dr. Repchuk. I'm happy to answer the question.
Can't we say there's a difference in distinction between West Virginia University, which is a accredited university, I don't know if they're a member of the AAU, but potentially it's a research institution. It's been around for a long time, I would anticipate, and being a faculty member there versus working for a expert firm that has a history of, I'm not just going to call them issues for now, I'll listen to what the plaintiff has to say, because under either scenario, potentially, wouldn't your association and who you work for be potentially something that should be brought to the attention of the jury if it impacts your credibility? And that's kind of my query, because you have a large expert firm and he's employed or he's an independent contractor for that facility or that entity, and they help generate business for him that he apparently makes money off of. I don't know how you can separate them.
And I want to be clear, Your Honor, I'm not suggesting that the identity of his employer needs to be hidden from the jury, or that a potential bias for financial incentives needs to be hidden from the jury. What I'm suggesting is that a specific bad act alleged against another consultant in a large organization like that with which Dr. Rebchuk had no contact, no participation, no alleged association other than the happenstance of employment, is fair game for cross-examination.
And the only reason I bring it up because we all make a choice as to who we work for, right? We do. I mean, it's not like, and I would anticipate if someone was working for a organization that had some issues, maybe they might want to separate themselves from that organization.
Well, I think they may, Your Honor. I'm sure Dr. Rebchuk has gone through some calculus, but that doesn't go to his character. That doesn't satisfy 50.085, and that's not a prior bad act that's admissible. And there has to be a statutory hook here somewhere. And the one that the plaintiff cited, 50.085, only works for Dr. Rebchuk's personal acts and omissions.
What about 50075, impeachment? Any issue there?
Well, what would again, that would be related to, Dr. Rebchuk is subject to any impeachment evidence. So if he's done something, if he said something before and he changes his testimony, that's fair game. If he's got September 30th in his report, he thought that was the start date for the Henderson operations. He later, at deposition, he revised that and said, you're right, Mr. Kemp, I think it might have started earlier. That's perfectly fair game. He can be impeached with that difference. He can't be impeached with a hearsay article from the environmental working group on something that another consultant at Exponent is alleged to have done years before that Dr. Rebchuk had no involvement with. So one is fair game, Your Honor. It's the witness's acts and omissions are absolutely subject to cross-examination. But the sins of others, the corporate character, so to speak, is not. We don't paint people with a character brush that broadly. And you're not responsible for things that other judges who wear a black robe do or don't do. And I'm not responsible for things that other attorneys at McGuire Woods do or don't do. We may want to police that to the extent we have visibility into it. And if Dr. Rebchuk saw some misconduct and failed to take action, I suppose that would be fair game for impeachment as well. But nothing of that sort is alleged here. And nothing of that sort, Your Honor, is the subject of the motion. So I want to be very clear about what we're seeking to preclude and what is obviously fair game.
All right.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor. Eric Pepperman for plaintiffs. I know Mr. Neale has stated repeatedly that he wants to be very clear about what they're seeking to exclude, but I'm not sure that it is very clear. What it seems to me is that they are trying to preclude cross-examination on bias and an association and motivation in being employed by Exponent. If you work for an opinion factory, you should be able to tell the jury that he works for an opinion factory. That goes to his bias, his credibility, and his motivation to give the opinions that he's giving in this case, which is fair game for impeachment. And I want to be clear myself. What we are talking about here is bias. And I think this is exhibited in UNFI's own motion, where they cite the book by Dr. Smith. This is a pretty astonishing citation, in my view, because this is a former assistant secretary of labor for OSHA who wrote a book about Exponent's well-known bias towards corporate clientele. The thesis of the book, just like the thesis of the articles that we attached as potential exhibits and that exist in wide variety, is that if a corporate defendant needs a favorable expert reporter opinion, you go to exponent. That is a bias. That is a reality. Exponent is a well-known opinion factory, and again, if you work for an opinion factory, we should be able to bring that fact up when we're examining him on his opinions. The argument really is, well, yeah, exponent may be an opinion factory. Yeah, it may be well known that if you need a favorable opinion, you go to exponent. But that's exponent. That's not Dr. Revchuk here. But, Your Honor, and you alluded to this, you can't disentangle the two. UNFI didn't retain Dr. Revchuk. They retained exponent, who employs Dr. Revchuk and obviously exercises a degree of control and influence over its employees. After being retained by UNFI, Exponent assigned its employee, Dr. Revchuk, to prepare the Exponent reports that UNFI produced in this case. UNFI did not pay Revchuk directly for his work on the Exponent reports. UNFI exclusively paid Exponent for the Exponent reports. These are reports and opinions commissioned by UNFI on which Dr. Revchuk was assigned and worked. They're unequivocally Exponent reports. And Chris, if you can please pull up Exhibit 1 to the opposition. Your Honor, we attached this exhibit, but it's a few pages from the initial expert report by Dr. Revchuk. This is the cover page, clearly Exponent. This is an Exponent report. Trying to take Exponent off the page is not a proper motion in limine in our view. If you go to the next page of this exhibit, blow that up, Chris. This is the limitations page in the expert report. It doesn't say Dr. Revchuk. It says this report summarizes work performed to date and presents the findings resulting from that work. The findings presented herein are made to a reasonable degree of scientific engineering and certainty. Exponent Inc. reserves the right to supplement this report and to expand or modify opinions based on review of additional materials. So this is Exponent reserving the right to modify and supplement the report. And as I understand it, this isn't just, yeah, Dr. Revchuk is the main author, he's the mouthpiece, but he's not the only Exponent employee who worked on this report. This report reflects contributions of Exponent, including its other employees. If you can go to the last page of this exhibit, Chris, please. Finally, this is the compensation. It says at the very bottom, last line, Exponent is compensated at my standard billing rate. So they're not paying Dr. Revchuk, they're paying Exponent. Exponent has influence and control over Dr. Revchuk and has their bias is inextricably intertwined with this report. But we cannot cross-examine Exponent. We can only cross-examine Revchuk. And Chris, could you please pull up the motion and go to page 6? In the motion where they cite Dr. Smith's book, I found it very striking because the quoted language from the book that UNFI itself quoted and highlighted in its motion, I think explains this point very well and illustrates it. So Dr. Smith writes that as the product defense work has gotten more and more specialized, the makeup of the business has changed. Generic public relations operations like Hill and Knowlton have been eclipsed by product defense firms, specialty boutiques run by scientists. Skipping down a little bit. Their business model is straightforward. They profit in helping corporations minimize public health and environmental protection and fight claims of injury and illness. In field after field, year after year, the same handful of individuals and companies comes up again and again. The range of their work is impressive. They have on their payrolls or can bring in on a moment's notice toxicologists, epidemiologists, biostatisticians, risk assessors, and any other professionally trained media savvy experts deemed necessary. Exponent scientists are prolific writers of scientific reports and papers. While some may exist, I have yet to see an exponent study that does not support the conclusion needed by the corporation or trade association that is paying its bill. So this idea that these companies are opinion factories and they bring in and pay the scientists, who are the mouthpieces, is how the business operation is modeled. And then they come in and say, well, it's not Exponent, it's only this guy. This guy wasn't involved in this, paying $40 million for asbestos research that doubted that asbestos causes cancer, or paying, millions of dollars for opinions that secondhand smoke really isn't that bad for tobacco companies, and the list goes on, Your Honor. So this whole idea that you can separate the Exponent employee from Exponent and the Exponent report is a false distinction. So the argument is not only wrong because you can't separate the two, it's also belied by Nevada law. And Mr. Neale did reference this to try to minimize it by saying, oh, well, yeah, you can cross-examine on bias, but we're not seeking to preclude them from cross-examining on bias. But that's exactly what they're doing. And they say...
Well, actually, it's broader than that. I mean, pursuant to 50.115, you're talking about, it deals with the mode and order and interrogation and presentation of evidence, right, and examination of a witness. And cross-examination is limited to the subject matter of the direct examination and matters affecting the credibility of a witness.
Yes, Your Honor, and I will
That's
build
different.
upon
That's different, right, than the 50085 issue, right? That's different. We're talking about, and the reason I'm bringing this up, I mean, I've seen many cross-examination, and a lot of things come. How much are you getting paid? How much work have you done for this defendant or this plaintiff? And what's your relationships? And the list goes kind of on and on. Lawyers get very creative.
Yes, Your Honor, you're exactly right. And I'll even build on that because I'll refer the court to Lovato v. States, 120 Nevada 512. And this is at page 519. And it's talking about the modes of impeachment, what kind of impeachment is allowed on cross-examination. And it says, quote, "And extrinsic evidence relevant to prove a witness's motive to testify in a certain way, i.e. bias, interest, corruption, or prejudice, is never collateral to the controversy and not subject to the limitations contained in NRS 50.085 subsection 3. It goes on page 520, talks about the trial court's broad discretion on limiting and controlling cross-examination, but it references that a trial court's discretion is narrowed where bias, motive, is the object to be shown, and an examiner must be permitted to elicit any facts which might color a witness's testimony. Generally, the only proper restriction should be those inquiries which are repetitive, irrelevant, vague, speculative, or designed merely to harass, annoy, or humiliate the witness." And so I think what the court is saying in its inclination is exactly correct. Eliciting these types of facts about the association with Exponent, about their incentives to give opinions favorable to Exponent's clientele, those are all fair game for cross-examination and subject to the reasonable restrictions exercised by this court.
I mean, the examples happen. How often do you testify on behalf of the defense?
Right.
I mean, how often do you testify on behalf of the plaintiff? There's a lot that goes on.
Exactly, Your Honor, and I think just the last thing to address is this argument that all these articles are hearsay and inadmissible and not subject to the cross-examination. Well, I think this is a difficult issue to address in the vacuum that we're in now. We haven't prepared the cross-examination of Dr. Revchuk. I'm not sure that we would even seek to introduce any of the articles or to what extent. We could ask him about his acute knowledge of the association and exponent bias prior issues, and he may have personal knowledge where we don't even need to reference any of these articles. If we do need to admit them, potentially, to some extent, I would just point out that NRS 51.285 provides a hearsay exception regarding reputation of a person's state character. It provides reputation of a person's character among the person's associates or in the community is not inadmissible under the hearsay rule. So this goes back to Exponent as a corporation, as the author and ultimate controller of the report, that it speaks through Revchuk. So we think that these articles, to at least some extent, would be admissible as under this hearsay exception, but we're not there yet. All we're doing here is you're being asked to exclude any ability to cross-examine Dr. Revchuk on this topic. And I think Your Honor sees the flaws in that request, and for all the reasons outlined in the motion in opposition and just now, we'd ask you to deny the motion.
Okay, thanks, sir.
Judge, what are you being paid? How often do you testify for defendants? How many cases have you worked on with Mr. Hoffman or Mr. Neale or McGuire Woods? Is this the 17th time or the 217th time you've been retained by these guys? That's all fine. That's all fair game.
What about his associations and that he's associated with as far as firms are concerned?
You work for Exponent. You're aware that Exponent has been involved in controversial environmental matters for years. You're aware that you draw your paycheck from Exponent. Exponent has 1,000 consultants around the world. Exponent's clients include General Motors and Ford and whoever else. That's all fair game. That's fine. There's no problem there at all, Your Honor. That's the wide latitude that cross-examination entitles one to. What it doesn't entitle one to is to malign a witness with the acts or omissions of others. And so when we get to specific
But
conduct,
you're saying acts or omissions of a firm he's associated
not of the
with?
firm, no sir, not of the firm.
Okay, but I mean, doesn't that go to its credibility? And that's why, I understand there was a discussion regarding 50.085, but 51.115 deals with more specifically with cross-examination, and it can be, let me make sure I get it correct, cross-examination is limited to subject matter of the direct examination and matters affecting the credibility of a witness. And here's my point. Now, I'm not saying, because I don't think we've drilled down on this, but I'm not saying that what articles come in or they do, hearsay or whatever at this point. But it seems to me, like for example, I'm an expert witness and conducting opinions in legal malpractice cases. And if I'm affiliated with a firm that's had some historical problems, I think the adverse counsel would have a right to bring that up. And because you know, it's one of these things where you don't an expert shouldn't be able to obtain the benefits of being with a large firm without accepting the burdens that go along with that. And that's kind of how I see it, because if you're with them and they're big and if they've had problems, why can't the jury find out about that problem in order to assess his credibility? Now, I haven't dug deep as far as what comes in, but it seems to me in a general sense, if you're an expert witness and you hit the stand, in a general sense, your credibility's impacted and can be attacked.
We agree on that, Your Honor.
Yeah.
And we agree that if Dr. Revchuk has participated in, or sat silently and observed, or was made aware of and didn't protest.
Because he's an employee.
He's an employee,
He's an employee, right?
yes.
Oh, yeah, he's an employee. It's even more than just an association. He actually is an employee.
I understand him to be an employee. Your Honor. On that point, I'd like to just point out to the court, and again, Your Honor, I want to make clear, the subject of this motion is these articles that I've shown the court, and the book that we cited. I'm not trying to hamstring cross-examination. I'm trying to enforce the hearsay and the opinion rules. And those don't yield to 51.115 or to 50.085. This is Dr. Revchuk's report. Everything Dr. Revchuk does or fails to do is fair game. John, could you pull up the report, please? I just want to call the court's attention the personal responsibility that Dr. Revchuk unequivocally accepts for this report. Mr. Pepperman is mistaken. We did not retain exponent. We retained Dr. Revchuk, and this should make it clear. First of all, page 1 is labeled the expert report of Alex Revchuk. Page 2, please. Dr. Revchuk is the one and only individual, I'm sorry, John, page, scroll down if you would, please, one more page. Dr. Revchuk is the one and only expert who has signed this report and authored this report. Dr. Revchuk has placed his Nevada engineering seal on this report, and Your Honor, I just refer the court, you're probably already aware of this, NRS 625.383 is the statute that governs the use of an engineer's seal.
But the engineer's was not like a shield that precludes vigorous cross-examination.
Of course not. It invites it, but it says, this is my work, and I'm the one responsible for this. If this is not Dr. Revchuk's work, and he's putting his seal on it, he's violating that statute, and he's violating Nevada Administrative Code 625.610, which require him to identify the work as his own, precisely so that, Your Honor, we can fix responsibility with an individual. And that's what the character statute at 50.85 does. It says anything that this man does or fails to do is fair game. But it doesn't say that he's responsible for the sins of others. All we're trying to do is enforce that. John, if you could go please to page 13 of Dr. Revchuk's report. First paragraph, please. Next, I was retained. I was retained by McGuire Woods on behalf of UNFI. If Dr. Revchuk can be questioned, did somebody twist your arm about this? Did somebody at Exponent tell you that you need to change this part of your report? Absolutely fair game. No problem at all. But the court has to keep the articles out. Those are hearsay. Those are opinions. Those are matters that don't concern Dr. Revchuk's character. And it would be error to allow those, even under the wide latitude typically afforded cross-examination. Thank you, Your Honor.
This is what I'm going to do as far as this in limine motion. I want to be very clear. I'm going to deny it. As far as the admissibility of the articles, that could be another issue, right? And I understand that. I don't think that's been thoroughly vetted. But for example, there's been arguments regarding hearsay. And I don't remember this being thoroughly vetted, but there's a lot of hearsay exceptions, right? Here in the state of Nevada. And I'm not going to point to any specific one, but there's a lot. And we give you a chance to vet that as far as what could be admitted or not admitted. You can do it by trial briefs. When the time comes, we can deal with it. But, and that starts out with chapter 51. That's my recollection. But we'll deal with that later, whether the reports come in or not, and how they can be used. Okay, where do we go next?
The next motion in sequence, Your Honor, is UNFW's motion to eliminate number 16 to exclude lay medical opinions. Your Honor, there is a tremendous amount of overlap between this and the motion that Mr. Hoffman just argued, motion to eliminate 14 on the other complaints. I won't belabor this. I'm not arguing against the court's prior ruling.
Now, here's my question on that, because when it comes to strict products liability cases and the types of evidence that can be admitted as it pertains to some of the very specific issues we've discussed in the past is much different than, say, hypothetically, a plaintiff. And I understand what the plaintiff's burden is as far as establishing both general and special damages, right? And so I just want to make sure the record's really clear. For example, you have a simple auto case, a person suffers an injury in the lumbar spine, and they want to make a damage claim in front of the trial court or a jury. There has to be competent medical evidence, right? That's one thing. But and this is one of the reasons why I discussed this issue at the very outset, when we were discussing, okay, what kind of evidence is permissible as it pertains to other events from a strict products liability perspective. And we know this, and for example, and this is not directly on point, but we had this discussion regarding Krause, the Krause case earlier today, right? And my law clerk listens in, he's like my fact checker. And here's my point. If you look at the Krause case, and when it comes to issues regarding whether it's substantially similar or this similar, apparently, you look at the Krause case actually supports my decision. And this is what I mean. This is straight out of the case. Bloomquist was injured as he descended his ladder. And although he did not state he actually touched the release lever, the jury could draw this inference. And so my point is, if that's substantially similar, all he was doing was going up and down the ladder, right? That's straight out of Krause, right there. And so circling back to this issue, and that's kind of where I'm working from, because what did the Supreme Court say there? That the jury could reasonably draw this inference. Then we've had other cases that have been touched upon, and as it relates to this specific issue, and our Nevada Supreme Court, normally you have to have experts. I agree, when in a traditional tort case, in order to prove up general and special damages. But we can go to Krause. And the reason why I'm bringing this up, this is important. We go back to Krause, and it's dealing specifically with a manufacturing defect instruction, right? And what did our Supreme Court say there? Krause and Home Depot further argued that the district court erred in instructing the jury on a manufacturing defect, as Little presented no expert testimony regarding the existence of a manufacturing defect. We have previously held, however, that expert testimony is not always necessary to establish the existence of a manufacturing defect. Rather, evidence of unexpected dangerous malfunctions give rise to an inference of a manufacturing defect. In such situation, direct proof of a malfunction, malfunction's cause, is unnecessary. The circumstantial evidence of the malfunction can prove a manufacturing defect. And so I just want to make sure the record's really clear in this regard. When it comes to general tort law, personal injury, medical malpractice, I understand Morsicado, I understand Williams, I understand all the cases, I understand Giglio, 2 of the 3 were my cases as a trial judge. I get it. I mean, I understand the origin going back to was it Perez versus Las Vegas Medical Center, Prabhu versus Levine. I get it. But here's my point. We're kind of like in a different arena as it relates to circumstantial evidence and inferences. And here we're talking about circumstantial evidence and incidents and inferences as it regards other events, not the claim for relief. In this case, because I would anticipate at some point, when it comes to injury causation specifically relating to this plaintiff, Mr. Kemp's going to have some doc come up and testify about it.
No question.
Right? And so, and what I'm trying to do, I want to make sure we don't conflate. There's different standards.
May I, Your Honor?
Absolutely.
Thank you. I understand everything the court just said
Right.
about the sufficiency of evidence in a strict product liability case. Circumstantial evidence can be sufficient. Inferences can be sufficient. That, your expert testimony is not needed. Of course, the court is correct. All of that, Your Honor, deals with the sufficiency of admissible evidence. None of that, Your Honor, changes the rules of admissibility. And respectfully, I think that's what the issue is. Evidence still has to be admissible in a strict product liability action, even if it's circumstantial, and even if it's something the jury can draw an inference from. The admissibility analysis is completely separate from and antecedent to the sufficiency question. And very respectfully, Your Honor, I think the court has conflated the two. While circumstantial evidence and inferential evidence, even without an expert, may be enough to establish a defect, they don't change the rules of admissibility. And for evidence to come into this courtroom, even circumstantial evidence, even evidence from which only an inference can be drawn, it still has to be admissible. Now, I'm not trying to at all disabuse the court of, I believe the court erred, but the record is complete and I'm not moving to reconsider, I'm not arguing with the court.
No, and so you have to understand, that doesn't bother me at all. I mean, it doesn't, but I just want to make sure the record's clear. I mean, historically, we know that you would think that in a strict products liability case, you would have to have an expert to establish defect.
No, sir, absolutely not. That goes to the sufficiency of the evidence, and you do not need an expert.
Okay, why isn't, and I'm not talking about the plaintiff, but I'm talking about other potential victims and or individuals that were other evidences of defect. Why do you have to have expert testimony?
You don't, we've never said that, Your Honor.
Okay, so,
we
so
agree.
what are you saying then? I'm trying to make sure I understand.
May I say something?
Yeah, absolutely.
Okay.
I want to understand what's the focus on, because you're saying, look, Judge,
So-
you have to have expert medical testimony. For what?
Nobody has said you have to have expert medical testimony.
Okay.
I will not say that. That is nowhere in this motion does it say that.
What do you have to have?
You have to have competent evidence. So Mr. Hoffman argued competent admissible evidence. Mr. Hoffman argued 2 aspects of admissibility. Hearsay and substantial similarity be lost. I'm moving on.
All right.
There is a 3rd aspect of admissibility that the court needs to consider, and that's the preclusion of conjecture and speculation.
Okay.
Nobody can come into court, lay or expert, and say, I think it might be, I think A happened after B, therefore B might have caused A. Nobody can come into court and say, I have a suspicion. Nobody can come into court and say, I don't know exactly what my illness is from, but it could be. Because all of that invites exactly what the rules of evidence prohibit, which is idle speculation and conjecture. So this motion, Your Honor, is not at all targeted at the lack of experts. It's not a Morscano motion. It's not at all targeted at the hearsay problems that we've previously argued to the court and lost on, or the substantial similarity problems that we previously argued to the court and lost on. This is a speculation motion. You can't have lay witnesses, and I'm going to show the court 3 examples that say, I have a suspicion that this subsequent event was caused by the prior event because it came later in time. All right, and you've seen these before, Your Honor. I don't, again, I just want to make the record clear and then we'll move on.
Okay, but no, but I want to make sure the record's clear as far as facts. Would fact 1 be ingesting real water?
Yes.
Okay, all right. I want to tether to facts.
And let me put that fact in the context of the Nevada Supreme Court, because I know that's where the court's deeply rooted.
I am.
Wilson versus Circus. You may not assume causation from prior ingestion. Period. If you come into court and you say, I ate this and I got sick.
This one, sir.
Yes, sir.
Go ahead, sir.
If you come into court and you say, I ate a meal and I later got sick, Wilson versus Circus says no. You need much, much more than that. And so, of course, it all starts with ingestion. I would point out to the court, I'm not sure all those prior complaints did, but in any event. If we could play, please, Jeff Desitel, the gallbladder video. Each one of these is going to take about 2 minutes, Your Honor.
Take your time.
I appreciate the court's patience.
Take your time. I'm here that's what I said, right, Mr. Odou, I'm here every day.
Yes, sir.
Okay.
Did you drink any of the real water? I had it come into my house.
You had home delivered?
Yes, 5-gallon cans.
Okay. For what time period?
From 2016 to when the news broke.
2020?
Yes,
So did you personally drink it?
yes.
Wife drank it?
Son, daughter,
Good.
friends, everybody.
Any medical incidents involving anybody?
Nothing I can prove.
Any suspected medical incidents?
Well, of course.
Can we stop there for
What
one
did
second,
you
John?
suspect?
Okay, wait. Yeah, I'm listening. We'll stop right there.
Did you have a suspected medical incident?
Okay.
Did you, Mr. Desitel, suspect a medical incident? All right. Nothing, I'm sorry, go ahead, John, if you would, please.
Was to the rise of.
Well, my daughter's gallbladder had to be removed.
Okay. Approximately what was that?
2 years ago.
So today is 2022, that would have been in 2020?
Yes,
Yeah,
yes, before she left.
Is that before or after you heard of the outbreak?
I don't remember.
Okay. There came a time that you read the newspapers, heard.
I can almost swear it was before. She had gallbladder problems.
Can you stop there, John?
You know,
We have a father talking about a daughter's gallbladder problems. We have him saying, go ahead, John.
digestive problems, and the doctor said it was her gallbladder.
Okay. And so out of the 4 people in the house, everybody drank it pretty much equally, or she was the heavier user?
6 to 7 5-gallon jugs a week, or every 2 weeks.
Okay. Okay. And then other than your daughter, did anybody else in the house have problems?
Not that I'm aware of.
Any indications of elevated ALT or AST reads? Those are liver enzyme readings.
I personally haven't. My liver liver function's fine.
Good.
I have to ask my daughter.
Good. And you said she had gallbladder, well, she had gastrointestinal problems.
Yes,
And so they removed the gallbladder as a potential solution to that.
correct.
And as we sit today, do you know whether or not she had elevated ALT or AST?
I'm not for sure. I'd have to ask her doctor.
And after you heard the news of the outbreak, did you attribute her gallbladder condition potentially to real water injection?
Never put two and two together. I didn't even think about it. You know, you assume drinking water's safe.
Right. You assume that?
Yep.
All right, Your Honor. We have a father speaking of his daughter's illness, an illness, as Mr. Hoffman has said, that nobody else in this outbreak has. Is there anything you suspect? Yes, I suspect my daughter's gallbladder problem. He never even ties it to the consumption of real water. He says there's nothing I could prove. It's just what I suspect. There are no other problems among any other members of the same household. I'm not sure of any liver issue. Is that something that you attribute potentially to the consumption of real water was the question. A layperson can't attribute anything. Nobody can attribute something potentially. And the witness's answer was, I never put two and two together. You assume drinking water is going to be safe. In this case, Your Honor, we have the lay witness doesn't even try to connect the two, not that he could. So there's no competent evidence there that's admissible. Would have and could have and potentially and suspicion are simply not competent evidence. All that does is invite speculation.
Now, here's my question, does the Wilson case really support your position? Because that's not a strict products liability case. That's a food poisoning case involving salmonella at the Circus Hotel.
Your Honor, that's a strict liability case.
Is this, where does it
Yes.
say that? It's on negligence. I got it right in front of me.
Your Honor, there's a strict liability count there, I believe. I take that back.
Well,
I'm
I'm just
sorry.
looking here, and interestingly enough, the trial court granted, without medical evidence, a directed verdict for the defense. And the trial court was reversed on appeal.
That's right, sir.
According to mine. And so, they said there was enough to go to the jury in this case.
Your Honor, there was a doctor who testified in that case. It says very clearly in that case that illness following ingestion is not sufficient to prove causation. The point is this, Your Honor, there's not a separate standard of admissibility for negligence and strict liability. There's a separate standard of sufficiency, not admissibility. What Mr. Desitel just did is say there might be a connection I don't know. He's not even speaking of his own symptoms, Your Honor. That's not possibly competent evidence that's admissible. Potentially attribute, I never put two and two together, nothing I can prove, suspicion. It would be error to admit that, Your Honor.
And you are right, they did have a medical doctor testify. You're right.
And the doctor gave a causation opinion that, I forget the timing relative to Moriscano, but he gave an admissible medical opinion.
Oh, he did,
Causation.
he did.
And so here, we not,
1985.
we not
But
only,
it's right on line. But see, here's my point, and everyone can correct me if I'm wrong, when I'm making this distinction. See, here, he was the plaintiff, and it's his burden in this specific case to establish pursuant to go back, this is 85, probably it's Bravo versus Levine, Perez versus Las Vegas Medical Center, in that time period, right? Okay, he's making a claim for damages. This is different than the proof of product.
absolutely.
Defect, right? And so, and that's kind of my point. I don't mind just saying this. That's why, after I listened to the rigorous discussion and description as to what happened here, then I went back and did my own survey of Nevada products liability. I came back and I had a slightly different view on everything because I've read the cases. And so all I'm saying is this, I'm not saying, we don't disagree at all in this regard. if a plaintiff is seeking general and special damages in a personal injury case, we all know what the law is. And I'm not disagreeing that at all. I know what the law is in that area, right? But my point is this, what do you do? And that's why, as we started out today's discussion, I said, what type of evidence is admissible when it comes to a product liability case as it relates to other events? From a circumstantial evidence perspective and also relating to inferences.
Your Honor, circumstantial evidence and inferences are not standards of admissibility. They're standards for sufficiency. And before, you've respectfully, Your Honor, you've conflated the two. There is not a separate standard of admissibility for strict liability.
Relevance? Relevance, right? I mean, I'm just trying to figure out, because what types of, I mean, when I read, I mean, maybe did Justice Stiglitz conflate it? You know, I mean, I'm following what she's saying, and
I think they all conflated it in Mr. Neale's view.
I mean,
Your Honor, I don't know that I don't remember the Ford Motor Company talking about the admissibility of the evidence. It's talking about the sufficiency of the evidence to support the verdict.
and the sufficiency could be circumstantial,
Absolutely.
right?
But it still has to be admissible, Your Honor. That's the only point. You can't skip the admissibility analysis because it's a strict liability case, and I'm afraid that's what the court's done. I'll move on, but let me just point out the problems with Ms. Kessler's testimony, not from a substantial similarity perspective, not from a hearsay perspective, but from a speculation perspective. Testimony can't be speculative or conjectural. I hope we agree on that.
We can.
But she says, I don't know what my fatty liver is from. That's page 22 at 19 to 20. When did you develop it? I don't know exactly. Do you have a suspicion? Was the question. At 25, page 25, line 21, through page 26, line 4. The answer is, I'm just wondering if real water could have been the problem. Your Honor, wondering whether real water could have been the problem is layperson speculation that is not admissible.
Here's a question I have for you, and we'll circle back to the Prowse case. We had a significant discussion on this morning.
Yes, sir.
The plaintiff didn't know what caused him to fall.
The plaintiff didn't know what caused him to fall, Your Honor?
Well, I mean, right here, oh, I'm sorry, was Bloomquist, put it this way, one of the other cases didn't know what, Bloomquist was injured. This is one of the 4 cases, I guess. And he was injured as he descended his ladder. And although he did not state that he actually touched the release lever, the jury could reasonably draw this inference as he descended the ladder. And so my point, what I'm trying to say is, apparently, that was excluded. The court felt it shouldn't have been excluded. And the way I read it, he didn't state that he actually touched the release lever that was alleged to be defective.
I don't think he testified, Your Honor, but.
Well, as far as the evidence coming in, and that's kind of what we have here, because what you're saying is this, and I think, and I understand this, and you're not mind telling me this, you're saying, look, the plaintiff cannot identify, because they're not a medical doctor, what the cause of their ailment or injury was. Consequently, they should be precluded from testifying, right?
Well, that's part of it. The other part is that if.
But there are no plaintiff's case, no other other exposures can come in.
No, sir, I've misspoken if that's what the court took away. What can't come in is somebody sitting on the witness stand and saying what these witnesses just said. I have a suspicion it potentially could have been, I'm just wondering if. None of that is admissible. Now, Your Honor, I've made the record. Strict
And
liability.
you're right, I'm talking about similar events, and a similar event would have been the Bloomquist event, right? And these are similar events we're talking about here. And my point is, with Bloomquist, the court said, you know what, and he did not, or no one identified that the defect at issue from this standpoint, where he was descending the ladder, that he actually touched the release lever, right? But the way I read this, the Supreme Court said, well, that similar event should have come in. And maybe it's based upon the fact that he was on the ladder, right? And that's substantially similar enough.
Your Honor, one final point. I made my record. Thank you for patiently listening. If it's enough to get on the witness stand, or not even a witness stand, if it's enough to hear from your neighbor that an illness subsequent to ingestion of water may have been caused by that water, that's Mr. Pham.
Well, I'm looking at that.
I understand, Your Honor.
I'm looking at that one.
And I hope you'll look at it from two angles. One
I
is
understand. I'm looking
one
at
is the
that.
hearsay, and we can apply this to Desitel or Kessler or Pham. Judge, under your analysis, anything that happens to anybody medically after they drink real water is admissible. Cancer, heart attack.
But I don't think have you presented cancer cases?
Well, it's the only thing we have, Your Honor. In this case, we have an ambulance ride for an unknown reason, a fatty liver disease, which the plaintiff's causation expert says is almost always caused by obesity, and a gallbladder. Anything bad that happens to anybody after they drink real water is admissible under the standard you just announced. And it doesn't, all I have to do is sit there and say, look, could have been. I wonder if.
So tell me, what is the limitation on drawing reasonable inferences and/or circumstantial evidence? What's the limitation?
Well,
As far as similar accidents are concerned.
that's why we have a separate freestanding body of the law of admissible evidence. So if the evidence is admissible, and Mr. Hoffman made this point, Mr. Odou made this point, then it comes in. To be admissible, though, it can't be hearsay, right? It has to have an indicia of trustworthiness enough
I
to
understand that.
clear that hurdle. It has to be substantially similar. I think that requires, as Mr. Hoffman unsuccessfully argued, at least the same mechanism of injury and at least the same manifestation of injury.
Well, and I understand that, but if we didn't have the same mechanism of injury directly with direct evidence, as far as similar accidents are concerned, with Mr. Bloomquist in the Krause case.
Well, I think we did, Your Honor. I think we had the activation of the lever.
No, we don't, because direct from the case it says, although he did not state he actually touched the release lever.
Your Honor, it says the jury may reasonably infer that coming down the ladder.
Exactly,
The
that's
ladder
my point.
All right, so
That's my point. And see, and I'm trying, this is the one distinction I'm making. This is important. If you're saying, I mean, hypothetically, what the trial court did before, they excluded that evidence.
They did.
Because they did. And then when it came back, the Supreme Court said, that's why maybe they shouldn't have excluded.
that one was close enough.
Okay.
That one was close enough. And what I hear the court saying is that any medical condition that happens to anybody after they ingest real water is close enough.
No, I'm not going that far. I'm looking at it from this perspective. Because hypothetically, say someone ingested real water and 2 years later they have an issue. That might be too remote.
Well, that's Mr. Haley. That's a good example.
All right, well, we'll look at that.
I agree with the court wholeheartedly.
Can we just argue the motion in front of us rather than have this?
Okay.
I know
But
it's Friday afternoon, but still.
It is Friday afternoon. I'll sit down, Your Honor. This
But
is
is
the
there
point.
anything else you needed, though?
Yes, let me leave you with this. The court has educated all of us on the standards for the sufficiency of evidence in a strict liability, product liability case.
As it relates to similar accidents or events.
Well, I'm not, the court's talked about the sufficiency of evidence. It may be circumstantial and it may be inferential. What there is a completely separate analysis about the admissibility of the evidence. And even circumstantial evidence has to be admissible and competent. And even inferential evidence has to be admissible and competent. And I suspect, or it could potentially be, or I'm just wondering if, is idle speculation and conjecture. It doesn't come in from an expert, it doesn't come in from a lay witness, it's not admissible. And that's why those three examples, Kessler, Pham, and
Oh, you live there?
Desentel,
Really?
Move on.
No.
should be out. Thank you, Your Honor.
Thank you, sir. Mr. Odou, sir.
Thank you, Your Honor. We had joined, it doesn't appear on the docket, but I just want to make the record clear that Clearwater had joined. And I just want to make one point, Your Honor. You read from the Broussard case, he testified,
Which one is that?
the inference, right?
There's a few of them.
Yeah, I know. For the latter case, he said he testified that he wasn't sure if he touched the release mechanism.
That's Kraus.
Kraus. Okay, so in the Kraus case, he testified. That's the point we're making. It's not his dad testified that he told him that he fell off the ladder. The reasonable inference is coming from the direct testimony, not hearsay testimony, but the direct testimony. He testified he went down the ladder. That's admissible. He says it. But if his mom or dad said, he told me he went down the ladder,
I understand your
that's the
distinction.
difference we're making, Your Honor.
I understand your distinction.
Thank you, Your Honor.
One point as well, Scott Rasmussen on behalf of Hanna Instruments, we did file a joinder on the court docket. I do not know the number, but I do have a date, June 30th, 2023.
I accept it.
Thank you, Your Honor. Worried. So my point is this, is that I went through a lot of these depositions with people and asked them all, do you know anything about ORP meters? Do you know anything about ORP meters? Do you know anything about? Many of these questions were asked to lay witnesses, okay?
Right.
I am concerned that I'm going to get people that either work for Real Water or are plaintiffs or, and we'll deal with the expert question later down the road, that say, oh, isn't that ORP meter some sort of a medical device that tells me that this Real Water's safe? Now, there's a problem because is this, I started out with this, oh, I don't know anything about your meter. I don't know a darn thing, but maybe I was told by someone hearsay, shouldn't that be admissible that this is a safety device of some sort and it should make sure that everything is safe and wonderful and we all live in a wonderful world somewhere, and it doesn't. And the reason I joined is to prevent someone from saying, this lay witness can give some sort of a medical opinion that an ORP meter now is a medical device that somehow made things safe so that nobody would get sick or get injured. The product is Real Water, mine is not, and with regard to this motion, it should be granted that lay witnesses cannot get up there if they have no scientific background, even if they were using the ORP meter and say, oh, yeah, people got injured, so this must have failed. And that can't be the result of a measuring device like this. That's my point, and I hope that for that reason and for my client, this motion is granted.
Okay. Anyone else in the,
Thank you.
Your Honor, we joined, but for the same reasons already expressed.
okay, thank you.
You know, remember the play Hamlet by William Shakespeare was 3 hours long. That was the one where they said, to be or not to be, that's the question. That's Hamlet. That lasted 3 hours. Motion 10B, not to be, 10B, we started on Tuesday. And Mr. Hoffman's argued it 3 times. Mr. Neale's done it 3 times. Mr. Odou's probably had 6 shots at it. By my count, we've spent 12 hours arguing this issue since Tuesday. As Mr. Parker aptly put it, this isn't Groundhog Day. This is Groundhog Day, followed by Groundhog Day, followed by Groundhog Day. And now we're on our 4th day of Groundhog Day. Okay, at some point, we have to stick to the actual motions rather than try to use them as a leaping off point to re-argue 10B. So why don't we start with the real motion that they filed in this case? Can we put it up? Okay, let's go to the body of the motion. This is a 2-page motion, Your Honor. Go ahead, next page, please. Next, let's get to the argument. Okay. These are the points and authorities, all right? We should not issue medical causation opinions from laypersons. Okay? Go on and on. Go through it. Conspicuously absent in this motion is any mention of Lois Kessler, any mention of Mr. Desital, any mention of Mr. Fisher, any mention of Mr. Watkins, or any mention of Mr. Pham. They did not raise any of those subjects in this motion, Your Honor. So when we opposed it, we said, this motion cannot be granted because it's amorphous. There's no witness's name.
There's no context.
There's no context. It's a big guessing game, okay? So that was our opposition. However, we did say, well, maybe they're trying to get to Mr. Jones, Wayne Jones's testimony here, that he drank real water while he was on the Utah trip, and he's one of the probable cases. Maybe that's what they're trying to get to. So we did discuss that a little bit in the opposition, okay? Then, when we got to the reply, all of a sudden we see the name Kessler, Fisher, Watkins, Desital, Pham, all people that were the subject of 10B that the court has already ruled upon. Like I said, this is Groundhog Day. We've had rulings on this over and over and over again. So with regards to the motion that was actually filed, it should be denied because there's no specificity. But assuming for the sake of argument that we're going to argue this 10B yet one more time, Your Honor, we would just quickly incorporate the points we made. And you know, how they keep saying Mr. Pham's testimony is hearsay when twice he watched them go by on the ambulance. It wasn't Mr. Pham's father that watched him and told Mr. Pham. It was Mr. Pham himself. It was Mr. Pham, while he was employed at Real Water, that recommended these people go to. He was employed by Real Water when he did this. He recommended that they go buy Real Water at Whole Foods. So, you know, I've already pointed out, you don't get taken away in an ambulance in the middle of the day unless you have some sort of medical emergency. So do we need to show exactly what sort of medical emergency that is? No, we don't need to show that. And so now they're trying to morph this, you know, they always come back to the same thing. Oh, Judge, this isn't admissible unless we have an expert who's examined the prior incident and he's giving us an expert causation opinion. That is not the requirement for prior injury admission. And to the extent that they're trying to take this medical causation thing and go back 4 days later to 10B. Now I'm getting mistaken by this Hamlin analogy. But going back to 10B, Your Honor, if that's what this motion was directed to, first of all, it should have said so. But assuming it is directed to keeping out Kessler, Fisher, Watkins, Desital, and Pham, the court has already ruled on the first four, okay? The court has already entered a ruling allowing those prior incidences in. This motion didn't even use their names in the beginning of it. How can this possibly be morphed into something that overrules the previous motion? But, Your Honor, we would ask that it just be denied for lack of specificity. All these issues have already been teed up in the 10B motion. You're going to take a look at the Pham deposition and decide that in the context of another motion. This motion should just be flat out denied.
Plaintiff's opposition, please. Page 17.
Well, the plaintiff's opposition raised it because I'm a bunch
Excuse me, I'm sorry. I thought you were done what you meant.
No, Your Honor, just because I say something because I'm worried about it in the opposition doesn't mean he raised it. If he wants to show the court where he raised any of these instances in the 2 pages that I've already shown the court, I'd be happy to respond to it. But he didn't raise any of these points.
Your Honor, Mr. Kemp is correct. The names aren't there. Mr. Kemp knew exactly what evidence is concerned. On the screen is page 17 of his opposition. The subheader there at the bottom, please, John. Kessler, Pham, page 23, please. This has been a contentious issue at the depositions. It's been a contentious issue through discovery. There's no secret here. Page 20, can you blow that up, John, please? Decitel testimony. Judge, I'm going to leave it at this. Mr. Pham reported seeing 2 ambulances drive away from his neighbor's home.
You don't have to argue that.
Okay.
Look at the deposition.
Let me argue this.
Okay, sir, didn't I agree to take a look at the deposition transcript?
And
Wait a second here.
And
What page are you putting up there? Page 16 of my up on?
No.
What page is that?
This is 23.
Okay, Your Honor, this is the joint op to 10B and this motion, okay? That's where this is coming from. This isn't a separate opposition to 16 as counsel's representing. He's going back to the opposition we filed to 10B.
And 16. It's the same,
It's the,
Your Honor, if I may. I'm sorry, Mr. Kemper. I don't mean to interrupt you. Are you done with your argument?
go ahead.
Thank you. Your Honor, this is what we're asking the jury to do. And I don't want to, I know the court's looking at Pham for hearsay. If you'll let me say 2 sentences.
I've never stopped anyone from saying.
Thank you.
Go ahead.
Ambulances leave my neighbor's home. From that, I am to infer that they had acute liver failure as a result of real water. That's impermissible. That's speculation. Kessler's deposition. Kessler wonders if, potentially, real water could have been the cause of her fatty liver disease, which the plaintiff's causation expert says is almost always caused by obesity. That's idle speculation. You're inviting the jury to speculate and conjecture. That's impermissible. Mr. Decitel, my daughter had her gallbladder removed after she drank real water. Nobody has suggested that there's a problem with gallbladder removals. You're asking the jury to speculate that there is a causal relationship between the two because the injuries occurred subsequent to the ingestion of the water. That's impermissible speculation and conjecture. Separate and apart from the admissibility concerns under 10B, the court has to rule that things that potentially or perhaps or I'm wondering or could have been don't clear the evidentiary hurdle necessary for admissibility. Even in a strict liability case where competent circumstantial evidence could be substantial. Thank you.
Thanks, sir. All right. Just want to take a look at the motion.
Your Honor, weren't you considering taking a break about now for?
I am getting ready to take a break in just a couple of minutes, but I want to rule before I do.
Oh, I'm sorry.
No. There's a reason for this. I can't kick the can down the road. I gotta decide these motions, but I just wanted to make sure I had some clarity. And here's my point, and I hopefully the record is clear. Number one, as far as any prior motions I've ruled, right? If we want to file a motion for reconsideration, do so. I have no problem with that. Secondly, and I'm looking at the call to the question, and and here's the thing, and I keep coming back to this, and I want to make sure the record's really clear in one respect. I understand the distinction between medical causation, injury causation, and what the plaintiff's burden is in a tort case. I get that. But this is a somewhat different scenario here. And I know Mr. Hoffman loved Krauss. He talked about Krauss a lot. But my point is this. We're dealing with a different scenario here because we're talking about prior similar events, prior similar accidents. And under that circumstances, there's a different burden as far as sufficiency of evidence, and that's where inferences and or circumstantial evidence can be utilized. And so when I look at this, and the only reason I was going back looking at it, I mean, it's a very short motion, and from a particularity perspective, and I think that is kind of important to point out. For example, I'm looking at it, and it doesn't really say in the motion which specific testimony I should look at. And just as important too, there's cases here cited It said, for example, in order to qualify on causation, a medical expert cannot state in general terms, but must state in terms of a reasonable degree of medical certainty. Well, actually, it's not certainty, it's probability. That's Prabhu versus Levine, that's Perez versus Las Vegas Medical Center, right? And so I get it, but I'm not gonna let anyone conflate what the two different standards are. That's all I'm trying to say. I get it. I'm not gonna mix and match them and get confused by that. And that's my point. As far as, is it Mr. Flam? I'm gonna look at that and accept what you're saying regarding hearsay. I'm gonna see what the deposition testimony says. That's why I didn't rule on it. I understand. But the bottom line is this, we'll let the Nevada Supreme Court decide this ultimately. I look at prior similar events and those types of things. There's different standards, and the reason for that is from a policy perspective as pertains to the consumer expectations here in Nevada. We specifically rejected some of the negligent theories and requirements by not following the other standards, as risk utility. And that's my point, and we'll see what the Supreme Court does.
Thank you.
Time for a break, man? Deny the motion. Thank you, ma'am.
We'll come back 3:40, 3:45, what does Mr. Do need?
What do you need, sir? What do you need?
I'm fine with the,
What do you
my
need, Mr.
associate, Mr. Kaufman, I keep wanting to say Kaufman. Mr. Kaufman is online, and if the court will allow it, he's pro fiche,
He's fine.
then I'm fine with you all starting without me, and he can fill me in on anything I miss.
15?
Sounds great, John. Thank you.
All right.
3:32.